Go. Greetings. Today, May 17th, 2025, the advisory group of experts has gathered in full to conduct an interview with a candidate for the position of judge of the Constitutional Court of Ukraine, Nykon Olesia Zinovievna. In particular, all 6 members of the AGE are present. AGE Secretary Marina O'Connor, members of IGE, Mr. Alesh Zaler, Mr. Yaroslav Romanyuk, Ms. Hanna Sukhotska, Mr. Vasil Shahun, and actually I, head of the AGE, Oksana Vasilchenko. Also, we have 5 deputy members of the AGE, Mr. Volodymyr Kuzmenko, Mr. Vitaly Machinchuk, Mr. Marek Zubik, Mr. Tomar Griffith, present during the interview. I would like to note that we are working in a shelter, so in the event of an air raid alarm, the interview will continue without interruption. I would also like to remind that the interview is being recorded and broadcasted live on the AGE resources and the CCU website. Therefore, I draw the attention of the AGE members and the candidate to the restriction of the use of sensitive data and information with limited access on live broadcast. If necessary, the AGE will limit the broadcast for the time of sensitive issue discussion. We are ready to begin. So now I will give the floor to the Secretary of the AGE. Please, Marine, the floor is yours.
Thank you, everyone who is watching us. As our chair, Ms. Vasilchenko, has already said, the advisory group of experts will now interview the candidate, Olesia Nykon. Let me remind you that the interview is a mandatory stage for evaluating the candidates as part of assessing their compliance with the criterion of high moral qualities. One interview takes approximately 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask all candidates to be concise, to answer the questions posed clearly, unambiguously, and obviously to the point. At the end of the interview, the candidate can make a short closing statement, no more than 5 minutes. I would also like to note that during the processing of materials about candidate Nykon, the AGE sent her questions for written explanations, so the candidate has had the opportunity to prepare and to provide answers. So now we have with us the candidate for the position of judge of the Constitutional Court of Ukraine, Olesia Nykon. Ms. Nykon is a judge of the Commercial Court of Lviv Oblast. The candidate is a lawyer with 20 years of experience in the field of law, 12 of which have been spent as a judge. She is a lecturer at the National School of Judges of Ukraine and has recently defended her dissertation on the digitalization of the justice system in Ukraine, theoretical and legal principles for the degree of Doctor of Philosophy in the field of law, specialty law. In addition, I would like to remind you that she has already taken part in the competitive selection last year and was interviewed by the advisory group of experts, although at that time her surname was Halamai. So, colleagues, we will now begin with our questions. Now, first of all, I would like to ask you, for confirmation on some of these statements that I'm going to make, you've previously participated in the competitive selection of candidates for the position of judge of the Constitutional Court of Ukraine regarding persons appointed by the Congress of Judges of Ukraine, announced on September 18, 2023, and during the previous competition, you provided answers to written questions of the advisory group and participated in interviews. Do you confirm all answers you previously provided within the framework of the previous competition that was announced, as I said, September 18, 2023? Is the microphone on? Your microphone? There we go.
Yes, I do confirm.
Do you wish to provide any additional information and supplement your written or oral answers that you provided during your participation in the previous competition?
Yes, Thank you. Actually, I would like to amend because during a previous interview, I actually pay attention to the fact that some information related to my former husband could not have been provided because he is a law enforcer. So please take it into account.
Thank you. We will now begin with Mr. Yaroslav.
Шановні колеги, оскільки
Dear colleagues, since now we will have a block of questions involving sensitive information, we kindly ask to limit the Dear colleagues, we may continue interviewing the candidate. Ms. Marin, please.
In your written responses to the questions of the advisory group, you stated that you owned an apartment at 13 Doroshenko Street in Lviv, apartment 6, which you sold on December 10th, 2013 for 235,167 hryvnias. You also owned a storage room in the same building, which you separated from the apartment in 2012 and obtained a separate certificate of ownership for it. Did you own any other real estate on Doroshenko Street in Lviv from the period of 2012 to the period of 2017?
Дякую.
Thank you for your question. So, between 2012 and 2013, I owned only apartment 58.7 square meters and the storage room mansard you mentioned. I had no other real estate properties in my ownership.
2012 to 2015, did you own the following real estate property? You said you did own it with the total area of 164 square meters. That was your apartment, correct?
Дякую за запитання. Ні.
Thank you for your question. No, it wasn't my apartment. Actually, after your inquiry, I checked this information and let me emphasize it. I alienated a property, attic, with an area of 16 square meters, which is proved by the purchase and sale agreement for this property and the copy of ownership title, a copy of technical passport. So I alienated this property to a third party, and subsequently this third party who purchased this real estate performed some actions to increase its area, subsequently resold it to a totally different owner, and then a totally different owner executed a title to a different real estate item. I have nothing to do with it. And the real estate I owned at Doroshenko 13th Street was an attic with an area of 16 square meters. I alienated, so I disposed of, and I have no relation to any other real estate items.
I hope it is clear, because otherwise I can explain in more detail.
Attic, this area that the 16 square meters, that was a separate apartment. Is that a fair statement?
Так.
Yes.
You lived in that separate apartment?
Ще раз зазначу.
Let me reiterate that temporarily we did stay there as of the end of the reporting period in 2014 because of some circumstances and some disagreements, which I explain in my written comment.
All right, after you left the apartment, after the separation from the apartment, was the property, the attic, assigned a flat number?
Well, when this attic was my property, there was no number assigned to the apartment now.
In your written answers to the questions within the current competition, you stated that the reason for separating the attic from the apartment in that building was the separation of a storage room, again, with separate facilities. You decided to separate them as it was before. In other words, originally it was separate, then it was joined together, and then you reestablished it as a separate living area. Is that a fair statement?
Так.
Yes.
And then again, we agreed that it's 16 square meters, and according to the sale and purchase agreement, it was sold for 10,000 hryvnias. Is that accurate?
Дякую за запитання.
Thank you for your question. According to the expert evaluation, evaluating this real estate object, it was alienated at that price with the reference to the report. They took into account the poor condition of this real estate property, the economic contribution, functional depreciation, and also that the state of the condition of the house. The opinion of the expert and the copy of that report is attached.
So the information would suggest that the sale price of 10,000 hryvnia is 40 times lower than the estimated market value. But you say that this property, because of its condition, was substantially worth less than what the market value report would suggest. Is that a fair statement?
Ще раз, якщо можна уточнити.
Let us clarify. I mean, this is about the attic, right? About 16 square meters.
You sold for 40 times lower than what the estimated market value would be for 16 square meter apartment.
Thank you for your question. I would disagree there. I mean, basically, the cost of this real estate property was evaluated by an expert, and that was, they took into account the technical condition and all the issues and the drawbacks. And again, that was an attic. The roof, they required major repairs. So me and my husband, we decided that it made no sense to repair that attic, because basically that's not just regular repair, that would require reconstruction. Hence, we decided to alienate that, and we ordered the valuation, and that was the cost. And let me emphasize that real estate property really required major repair. You can see the copies. There were cracks all along the facade and inside.
So you have a report from an expert that would indicate that $10,000, or excuse me, 10,000 hryvnia was a fair price when you sold it.
Так.
Yes. I did attach that expert opinion. I did attach this expert opinion. Thank you.
Let me then draw your attention then to the use of a car. Since 2017, you've been using a BMW car model X1, and that was manufactured in 2012, and it is in the name of your father. In other words, it's owned by your father, but you have been using this automobile free of charge. So according to the information reflected in your tax returns filings, the value of this car as of the date of acquisition of ownership was 231,652 hryvnia, which is approximately $9,000 based on the exchange rate back in January of 2017. At the same time, based on the analysis of information received from specialized trading platforms for the period from June 2017 to December 2017, the average sale price of a BMW car Model X1 manufactured in 2012 ranged from $19,500 to $23,800 US dollars. So can you explain what was the reason for the low cost of the car, the $9,000 that was paid for it, at the time of the purchase, and how was that determined?
Дякую вам за запитання.
Thank you for your question. Let me emphasize that this cost 231,652 hryvnias, 42 kopecks. That is customs clearance cost of that car. Because according to the explanation of the National Anti-Corruption Agency, in the declaration, I need to indicate the customs value. After the father bought this car, he paid all the customs fees that amounted to more than 105,000 hryvnias. So the total cost was 337,639 hryvnias, 99 kopecks, which back then was an equivalent to about $14,000. Moreover, that price was set taking into account the technical state condition of the car. This is my father's explanation, because there was deformation of the back right door, so there was a traffic accident. The turbine needed replacement, and also there were some other technical damage on the front and on the back, and again, all the photos of the car, the visual condition, I attached that all to the file as well. Hence the price.
So,
Склалось.
if I understand you, then you declared it for 9,000 US dollars, and then your father paid additional money that would bring up the cost of this automobile to $14,000, approximately. Why did you declare 9,000 if the real amount was 14,000?
Дякую.
Thank you. Let me reiterate that declaring of this $9,000, 231 something thousand hryvnias, it was due to the fact that back then the Ukrainian legislation stipulated that we need to only indicate the customs cost. So there were these explanations of the National Anti-Corruption Agency. There they clearly stated that if a car was bought abroad, then in the declaration we only indicate the customs clearance cost.
The custom clearance cost, how is that figured, that custom clearance cost?
Власне,
The customs cost, this is the one that is calculated, I'm not quite sure, but I believe it is broker or makler. Well, somehow they estimate this cost. Frankly speaking, I don't know details of that because I did not buy that car. It was my father who did. And he bought it, as far as I understand, well, he gave me all the documents and this expert declaration where that customs cost was indicated, and also he indicates he gave me all the invoices. This is customs clearance and the fee that is paid for registration of the property rights. So all of that is also attached to my written file.
The documents that would justify the initial cost for this vehicle, and you have documents that you have supplied that show the additional money then that your father paid in order to repair this car. And but it is your car for your use.
Так.
Okay, and you've declared that each time that since you've acquired the car, it's routinely been reported by you in your declarations, correct?
Так, уточню.
Yes, and let me clarify that the car belongs to my father. I only use it. Yes. Thank you.
So what we're concerned about is if an outside observer, a citizen, could they reasonably question the low value of the car? And would you be able to refute that impression by, as I said, a reasonable outside observer? And from what you've told us, you have the documentation to do just that, refute any doubts that the public might have about the acquisition of this car and its purchase price.
Так, звичайно, дякую.
Yes, of course. Thank you.
Олеся Зіновіна, дозвольте. Надалі.
Now let me proceed with the questions. In the period of 2012 through 2017, you were a graduate student, postgraduate student at Lviv State University of Internal Affairs. The topic of your dissertation research was custom in law, natural law approach. During your studies, you published a number of research articles, and they were published as part of the previous competition. The member of the group of experts, Ms. Kuznetsova, attracted your attention to the fact that in those articles you refer to the sources that are associated with the aggressor country, and she asked you whether you believe you need to remove those references where the authors are in the aggressor country. Have you done that? Thank you for that question. Yes, I've done that. I withdrew those references. Let me also mention that as of now, let me reiterate that I have used all possible steps to withdraw those references now, right? But why didn't you do that 8 or 10 years ago? Oh, I'm sorry, I didn't know about that procedure, that it is possible to officially withdraw those references. As soon as it became known to me, I used this opportunity, and I'm grateful to the previous speaker. And if you check my dossier immediately after the previous interview, 2 weeks after, I submitted that information. Yes, we checked that, and that's true. However, I am now holding this article, Custom as the Source of Roman Law and the Impact on National and International Legal System. The authors are assistant professors of Cherkasy State Technological University, and it was published in 2024 in November. Do you know this article? Could you repeat the title again? Yeah, I would like to pass it over to the Secretariat. To Olesia for the colleagues from the Secretariat, please. So, look, this article was published in November 2024. And in this paper, they quote you. Look, page 1 and the last page on the list of references. Yes, I didn't know about this article, but it means that in public domain, your articles remain, and some researchers use those and they refer to them in their research work. Yaroslav Mikhailovich, thank you for that question, but this question was not included in the list of written questions to me, so I am not quite ready to come up with a detailed answer. Let me just mention that on my side, I've done everything possible in order to fully remove my publications. And if these publications remain on the website, on Russian websites, there I could hardly do anything about that. But for Ukrainian websites, there they were withdrawn, my previous publications. And I can confirm that. I've provided you with that feedback from publishing houses and also the electronic platforms where these publications were available, the electronic library, Vernadsky Library. Well, maybe this is the process that's ongoing, but it has not yet been completed because, well, what you have now in your hands, it's in public domain, and this is not Russian internet space, that's Ukrainian internet website. So I believe you should continue working in that direction and make sure that all of those are withdrawn. Thank you. I will do my best to make sure that if it is still an issue, I will additionally do all the respective measures. And I believe I can explain that because in March, I remember this year, in March this year, I once again contacted the publishing house asking this question to them if they have submitted my application to Vernadsky Library, where they keep electronic copies of these publications. And they responded that they once again are going to contact the library, and they said that they did that. And these publications in the electronic form, they have been withdrawn. Yes, we also checked that. You're right saying that, but you see, that's still maybe an issue. Well, if that was a publication in 2024 and at the end of the year, yes, at the end of 2024, and as of March 2025, electronic versions of publications have been withdrawn.
So I took all the steps in order to withdraw these publications. Thank you. I have another question, and it's about one judgment in a case you considered. It's a decision you made in June 2017. The dispute involved the claims of the main directorate of the National Guard of Ukraine against private enterprise Znaibuddinvest, and according to the claim, the National Guard of Ukraine invested construction of a certain number of residential apartments for the National Guard servicemen. So, only around 30% of apartments were commissioned in line with this investment contract. Therefore, the main directorate of the National Guard of Ukraine filed a claim with the court and claimed the performance, and namely commissioning and transfer of all invested residential area. You dismissed this claim and you referred to the improper way of defense. Subsequently, the Court of Appeal overturned your decision and said that the defense method must be efficient to uphold the violation right. So, obviously, the content of the claim was for defendant to transfer to the plaintiff the actual quantity of residential area which was investment under construction investment contract. How would you comment this decision, this conclusion by the Court of Appeal? Do you accept it or not? What is your opinion about it? Thank you. Yaroslav Mikhailovich, if you don't mind, I will ask you a question. Are you aware about judgment in case 914/653/17 becoming effective, final and binding? No, I'm not aware of it. We rely to the decision 914/653/17. So your decision made by your court, decision dated June 21, 2017. So thank you for your question. If you are not aware, please let me explain. The subject of claim in the case you mentioned, I will just quote, to avoid taking extra time, was an obligation of the private enterprise to submit for approval and signature of the main Directorate of the National Guard of Ukraine properly substantiated proposals regarding transfer of apartments in line with investment contract number 27 dated June 2003, subject to addendum dated 2012 in form of list of residential apartments at constructed houses on construction in progress and their technical specifications. My decision was motivated by the fact that there was a judgment in case 914/486/15 dated December 15, 2015, and therefore there was a prejudicial which was a foundation of my decision. Let me just provide the quote. So as for prejudicial of established fact, in a case 9/4/486/15, it says that the plaintiff in this case was a Deputy Prosecutor General of Ukraine and the interests of the National Guard of Ukraine, and Lviv Commercial Court of Appeal established the following circumstances: that the claims regarding transfer of residential housing in any other way other than established by the contract through purchase of apartments on the secondary market and construction and transfer of residential area in other facilities constructed by the contractor are not claimed by the prosecutor, so by the plaintiff, and therefore it clearly says that this is efficient way to reinstate violated right. It will enable the plaintiff to reinstate the right which was violated. Moreover, it also says that the general prosecutor and the plaintiff have failed the offset mentioned in the letter by the main Directorate of the National Guard of Ukraine, and it fails to defies the evidence about offset of the cost of repair operations at the residential barracks and contribution in development of social infrastructure of the city of Lviv in proportion to the share of residential area owned by the plaintiff. Olesia Nykon, I'm sorry for interrupting you. Let's not quote court decisions. So are we correct to understand that your decision was based on the fact, on the prejudicial fact established by a court in a previous case, which was effective in binding? Yes, the court applicable to the same subject matter of distance, and the Court of Appeal explored the circumstances of this case and concluded that this method of defense will fail to produce the proper result. The Court of Appeal also highlighted the contradictory and conflicting terms of this agreement. So the plaintiff and prosecutor failed to prove the fact that there is a share of residential area to be transferred. Olesia Nykon, So you still insist that your decision was substantiated and reasonable? Yes, indeed. The facts were established. So in the case we discussed, the case heard by your court, was it a subsequent mistake by the Court of Appeal? Well, I cannot comment decisions by the Court of Appeal which already overturned my decision and highlighted that I was guided by the provisions of legislation and circumstances established in this judgment by the Court of Appeal heard prior to my case, applicable to the same subject matter of dispute and same grounds of dispute. Olesia Zinovna, could you please explain in a very simple word? There is investment contract, and there is a reasonable claim to fulfill obligations, perform obligations after investment contracts. So the contractor was required to transfer apartments in the house under construction. It's not any other real estate properties, not secondary housing pool to fulfill its obligation. So what was this about? Explain it in simple words. So the subject matter of claim in my case was submit for approval and sign substantiated proposal regarding transfer of such apartments. Let me highlight that the Court of Appeal established the fact that it will not be efficient to settle dispute. Why? I'm sorry, Yaroslav Mikhailovich, please let me finish. So the Court of Appeal also highlighted the fact that the terms of contracts provided for a possibility to transfer residential area in an alternative way acceptable by contract, except so through purchase of apartments on the secondary market by the defendant or transfer of residential area at other real estate properties constructed by the contractor. Moreover, the Court of Appeal established a contradictory terms in the agreement itself. Yes, we are aware of it. Let me just quote it, just to give you better understanding of this situation. So it says that there are effective terms of agreement which at the same time establish a duty of the customer to transfer a portion of residential to transfer to contractor and the contractor's duty to transfer a share to the customer. So these terms were contradictory, and the Court of Appeal made relevant conclusions after examining it. Moreover, in my decision, I also refer to provisions of the contract, and I clearly substantiated my motivation to dismiss this claim. Moreover, please pay attention to the fact that enforcement proceedings is still pending. So the decision of the Court of Appeal is still pending because it's an efficient way to reinstate violated rights. Olesia Zinovna, what is your average caseload? What's your caseload as compared to average caseload in your court? Similar to caseload of other judges. Any exact numbers? Figures. I'm not ready to give you accurate figure to describe my caseload. What the percentage of your decisions were challenged to the Court of Appeal? I believe approximately 40%, maybe 30%, 30 to 40%. Do you know the percentage of your judgments upheld by the Court of Appeal out of those heard by the Court of Appeal? Well, I have a high performance rate. And if we have around 30 judges, and I think I rank top 5 or top 4 by the rate of decisions upheld upheld by the Court of Appeal. Now I would like to give floor to my colleague for further questions. Thank you.
During your interview conducted by the advisory panel in March of 2024, you stated that you are preparing your dissertation research on the topic of the digitalization of the justice system in Ukraine, which you consider, as you stated, through the prism of the legal positions of the Constitutional Court of Ukraine. And one of the subsections of your research is related to the electronic activities of the Constitutional Court of Ukraine. As of today, you have already defended your dissertation research. What are the results?
Дуже дякую.
Thank you so much for this question. So, as of today, the defense session already happened. I successfully defended my research and I'm awarded with a degree of PhD in law.
Which
Дякую.
Thank you.
legal positions of the Constitutional Court of Ukraine, decisions, scientific conclusions, materials of public hearings were used and considered by you in the framework of your dissertation research?
Well, I took into account a number of legal positions of the Constitutional Court of Ukraine. In particular, they were a foundation of my PhD thesis. I also took into account judgments of the Constitutional Court dated 2022 about the rule of law, which is one of the foundational constitutional principles. In particular, let me highlight the fact that back in 2022, the Constitutional Court of Ukraine, in regards to the concept of legal definities, highlighted legal clarity, that legal certainty must be based on quality of legislative provisions and not the predictability of situation and legal relations. Also, I took into account the judgment of the Constitutional Court of Ukraine on the quality of parties to proceedings before the court and before the law, as well as a number of other legal positions, which have subsequently become a ground for a number of proposals I made, procedural changes to legislation. And as of today, these proposals are already submitted by myself to the parliamentary committee.
Research work includes separate section on the electronic activities of the Constitutional Court of Ukraine, what they are currently doing.
Thank you. Take into account the scope of my PhD thesis, the issues related to electronic proceedings at the Constitutional Court of Ukraine are mentioned only in section 2333 of my PhD thesis. So I separated. So right now I work on a separate article about electronic court procedure and its introduction into the system of constitutional justice in Ukraine. I already have some ideas and developments in this area, some ideas for research, and I'm researching this possibility. Well, let me dive a little bit deeper, if you don't mind. So if we focus on the functioning of the Constitutional Court of Ukraine, for example, plenary sessions of Grand Chamber or Senate of constitutional cases, constitutional complaints, and applications and submissions. So there are separate types of hearings. An open hearing where we can implement digital court proceedings such as video conference link, but there is also a closed plenary sessions when we need to be extremely diligent and extremely careful when implementing fully digital procedure. Because such plenary sessions are restricted and they are documented only by the minutes of the session. Moreover, please note that there are some other developments, but since today these concepts, developments and researches are not yet published, I will be able to provide it. I have submitted it for review, so I'm waiting for a review opinion and plan to publish it in the future. If you wish, I can share it with you for review.
Do you plan to apply the provisions of your research, and what you're telling me, it sounds like you are, you're going to apply the provisions of your research in practice in the judicial system and the administration of justice? You've suggested changes, and what I heard you say is that you suggested those changes to the Parliament, the committee that would be handling this in the Parliament, and would it take legislation of the Parliament then to enact your ideas, your concepts?
Yes, thank you for your question. So actually, I suggested a number of changes to the procedural legislation of Ukraine. And I believe that my proposals will be taken into account. If you don't mind, I will briefly outline the contents of these changes. It's about introduction and enabling branch offices and separate structural business units of legal entities to register electronic dashboards, electronic accounts, to facilitate the process and increase efficiency of hearing the disputes based on claims by legal entities and branch offices, because branch offices may act as plaintiff and as defendant in court. Moreover, I also made a proposal to enable the use of electronic court by expert forensic institutions, which may carry out expert forensic studies, examinations, because often it happens that courts order forensic examination, and after this forensic examination is ordered, the case is just suspending because case files are sent to forensic institution. It's very time-consuming process, so my proposal is to enable the use of electronic copies of documents for forensic examination. And if original documents are required, then a forensic expert may deliberately request them from court, for court.
Let me just maybe put clarification here. My understanding would be that you would be in favor of electronic filings. In other words, that causes of action, the plaintiffs, the petitioners could file electronically their paperwork rather than having to do actual paper. Is that one of your suggestions?
Yes, I definitely support this idea of submitting electronic copies of documents. So let me maybe ask you to clarify your question, because I'm a bit concerned.
To appeal to the Constitutional Court, you would, your recommendations then, what's contained in your dissertation would be a recommendation that instead of going to the court and filing papers, you could do it all online, do it digitally. Is that one of your recommendations?
Так,
Yes, of course. And of course, we need to take into account that we are in the situation of the martial law, so it makes sense to submit documents electronically. Because in any case, we need to implement digitalization into the system of the Constitutional Court of Ukraine as well. Yes, sorry, I'm a bit agitated.
і вам дякую.
Олеся
Thank you.
вже ви
So you are obviously active, you have active lifestyle, you don't just hear cases, but you also participate in various conferences, roundtables, you express your opinions, you work on your development, you have defended your thesis and the doctoral thesis you teach at the National School of Judges. And during the previous competition, we discovered that was not the only competition that you participated in back then. You confirmed that in parallel with the competition for Constitutional Court, you also compete in the competition for the Court of Appeals. Is that ongoing, and how much have you progressed there?
Питання. Під час
Thank you for your question. So, during the competition for the Court of Appeal, before the first test, I fell ill. Thus, I contacted the Higher Qualification Commission of Judges and asked them to postpone my test. However, the Qualification Commission indicated that my failure to come to the test is not an obstacle to holding the competition. So automatically I was rejected. So they believe that it's not important that you are unhealthy, but you must be at the test. Well, okay. Anyway, now you do not participate in that competition, right, for a Court of Appeal. However, you also voluntarily withdrew from the competition of the competition for the Constitutional Court last year after you completed this interview with the group of experts. Why? Because there was this question about my publications. I decided to suspend my participation in that competition, so that further on, as I mentioned, I could improve my academic background, and then I would reapply to make sure that I can keep working, and I could then confirm that I have conducted this research with the new topic of my dissertation, and so that the bystander did not have any doubts about my academic integrity. And I believe that makes sense, because then there will be clear understanding that I work with integrity. Okay, so then you suspended your participation because there was this reproach about lack of academic integrity, that in your papers, your articles, you referred to the authors that belong to the aggressor country. And in order to resolve that and to complete your work on your doctoral thesis, you suspended participating in the competition. Yes, but why now? Why have you reapplied now? So you have resolved those issues, right, that were voiced back then. So what's your motivation now? Why have you resubmitted? Well, my objective further on is that I work for the benefit of the society, of the state, also I defended my thesis, and I intend to further conduct my academic activities, academic work, because I want to develop, and I believe that my professional experience and knowledge of legislation, my wish to implement my academic endeavors, in particular in the field of e-governance, as I mentioned. So I believe that that's my motivation, and it persists. And I believe that I will be able to efficiently work on the position of a judge of the Constitutional Court of Ukraine. Thank you. That's it from me. Sorry, I'm agitated.
I have another set of questions for you based on your answers. You're obviously working full-time as a judge currently, correct?
Так.
Yes.
And you also worked on your PhD and you defended it. How long did it take you to write your dissertation?
Well, I needed more than 2 years, basically.
2 years, did you work with an advisor, an academic advisor, to help you with your direction and the details of your dissertation creation?
Yes, of course. According to the requirements, my research advisor helped me, provided support, and also read my paper, so acted as a consultant in the process.
It's all in 2 years while you're working full-time. How did you manage to do that kind of a schedule? It seems very intense and time-consuming, and you're also a mother taking care of children. Is that correct?
Thank you for that question. Yeah, of course, it took a lot of my time, and I took leaves, monthly, yearly, annual leaves, and also I used the additional leave and the kind of research leave, sabbatical leave, which I have the right to according to the legislation.
Those leaves are available to anybody who's a judge and working on their dissertation for academics. Is that accurate?
Так.
Okay.
Так.
All right. Well, thank you for those answers.
Дякую.
Okay. Does anyone have any further questions? No? Okay, as we mentioned at the beginning, you are now entitled to make what we would call closing statements and provide, this is your opportunity, and you have up to 5 minutes if you choose to do so.
Дякую.
Thank you. Dear members of the advisory group, thank you so much for this detailed discussion. Sorry for my agitation and maybe. So again, it has been so nice to meet you, to see you, and let me reiterate that I'm going to continue working on my elaborations and my achievements I'm going to develop in the field of academic work. I also would like to mention that my professional level, my teaching activities, and also the fact that I want to work, I have this desire to work as a judge of the Constitutional Court for the benefit of the constitutional justice body. I believe that I will be able to decently work on that position and to protect constitutional rights and liberties of citizens, individuals, and to ensure rule of law. Thank you. Thank you for your answers, Olesia. And now, dear colleagues, here we complete the interview with Olesia Nykon.